Hello everyone. Today legal stories come to you with words that you and I are familiar with. You have seen these words in contracts and agreements, but we tend to ignore them. Words such as exclusion clauses, limitation clauses, or disclaimers. Now these words have legal consequences. The purpose of these is to exclude or limit the rights of a person to a liability. Now let me explain to you the situations. Many of you would have purchased an airline ticket that got cancelled and you got stranded at the airport. Or you were looking forward to that exciting cable car ride, which turned out to be horrifying. The cable snapped, your head got injured, and you were left hanging in the air. Or you would have purchased a product, maybe your favorite phone or a music system, that refused to function after its first use. In all these cases, you have suffered physical, mental, and financial loss. In civil law, the remedy is a claim in damages or compensation. But here is the twist. The cable car operator, the airlines, or even the seller of the product would direct you to their exclusion or limitation clause in the contract. Now, these are perfectly valid clauses because they would have excluded the liability or limited them, for example, like a partial refund. However, as a consumer, the law intends to protect your right in certain circumstances. So what are those exceptions? Number one, such type of clauses must be incorporated at the time of the contract and not after. Number two, these clauses must be brought to the notice or attention of the consumer. Number three, if these are unfair and totally unreasonable, then you can challenge in a court of law. And lastly, if you have suffered any personal injury due to the negligence of the seller or the opposite party, then they cannot exclude their liability using these clauses. So as a consumer, one needs to be alert and check the validity of these clauses. If you find our videos informative, then keep watching, like and subscribe.